Hey, welcome back into Eye on Agriculture. I'm Britton Rucker. The Kansas Supreme Court has affirmed 2 lower courts with all of the opinions providing a thorough explanation of property rights with respect to road, ditch, right-of-ways, as well as the common law of trespass and nuisance and the application of the Kansas right to farm law. To help break down all of this, we're joined now with Roger McEowen, professor of agricultural law and taxation at Washburn University. Roger, if you will, let's start with a bit of the background of this case.
Well, good to be with you, Britton. You're right. There's a whole bunch of stuff to unpack in this court opinion. A lot of good stuff for agriculture coming out of this one. What you had was up on the Norton County, Phillips County border, the defendant who owned multiple farming operations, including a large-scale confinement hog operation. And what he did was install about 2 miles of pipeline in the road ditch right-of-way next to a public road to transport liquefied hog waste to spread on his crop fields down the road. He didn't get the adjacent landowner's permission to do that, and he didn't follow an applicable county permitting process. And that liquefied hog manure was then sprayed from a pivot irrigation system and an end gun within about 200 feet of a home of one of the plaintiffs that sued him for the nuisance problems. And those plaintiffs were also farmers, and so they were suing for nuisance and trespass. And because the spray from the pivot came within about 200 feet of one of their homes, and he lost in the trial court. He was hit with a total judgment just shy of $200,000, and the appellate court affirmed, and he sought review by the Kansas Supreme Court.
Yeah, and what did the Kansas Supreme Court decide?
Well, they affirmed on all points. He claimed that he was protected from the nuisance claim by the Kansas right to farm law, but you have to be in compliance with all state and federal laws to get the protection of the Kansas statute, and he wasn't. He had committed a trespass. You can't just appropriate somebody else's ditch rights, and that's the other component of this. A landowner adjacent to a public roadway owns the ditch, subject to an easement for the public to use that, and he wasn't using that for a public purpose. It was for his private purpose exclusively. So because he wasn't in compliance with all Kansas law, trespass law is common law, but it's part of Kansas law, he couldn't use the right to farm statute as a defense against the nuisance action.
So, Roger, help me break this down. How does this impact the regular Kansas farmer?
Well, every state has a right to farm law, and it's important to know the details of your particular state law. This involved the Kansas law, and common with a lot of other states is that the Kansas law requires conformity with all state laws, all federal laws and regulations as a prerequisite to being able to use the right to farm law as a defense. And he wasn't in compliance with trespass law, and so he couldn't use that to shield his conduct.
Well, Roger, thanks so much for coming on the program. Everyone stick around. Eye on Ag will be back after the break.